Google Gemini, or Judge Gemini, finds bias. Hearings 1 through 6 in 2022 with Cloyd Benjamin. Various hearings there. Also, Jason Methenvin sat in for Cloyd Benjamin during hearing 5. We've got a table of contents, introduction, background case. City of Natchitoches versus Travis Heinze. The City of Natchitoches charged Travis Heinze with one count, RS 14108 B1C, resisting an officer by refusing to provide his name to police in the Natchitoches Parish Public Library on January 22, 2022. The charge was prosecuted by Cloyd Benjamin Jr., Assistant District Attorney. The matter was in the court of Judge Robert C. Owsley. Trial and conviction was on April 11th, 2022. Various appeals. During the hearing of February 15th, Cloyd handed over CD and announced full disclosure. During the hearing of March 7, trial was set to March 23rd. During the hearing of March 21st, Cloyd revealed more evidence. Hearing 1. Alright, I'm not going to repeat these. I'm going to only say this once. Google Gemini find instances of personal bias and misconduct by the prosecutor, Mr. Benjamin, in the attached transcript of the hearing on February 15th, 2022. And then there were further prompts. For the previous output, please provide more detail with page references. Please continue to provide more detail. Please provide further detail analysis. Mr. Benjamin's potential personal bias against Mr. Heinze is evidence in the following instances. Unsupported accusations. Mr. Benjamin makes serious accusations against Mr. Heinze and his associates, claiming they engage in harassment and make threatening phone calls to his office. However, he fails to provide any evidence to support these claims, raising concerns about the veracity of his statements and suggesting a potential personal bias against the defendant. Obstructionist behavior. Mr. Benjamin initially refuses to provide his email address for the exchange of discovery materials, citing the alleged harassment as the reason. While concerns about harassment are valid, his unwillingness to explore alternative solutions and his dismissive attitude could be interpreted as an attempt to obstruct the legal process and may stem from a personal bias against Mr. Heinze. Derogatory language and personal attacks. Mr. Benjamin uses the term transient to describe Mr. Heinze. This term, often carrying negative connotations, can be perceived as a personal attack rather than an objective description. Additionally, he questions Mr. Heinze's credibility in court, accusing him of lying and using technicalities to evade justice. These personal attacks further suggest a potential bias against the defendant. Unequal treatment. Mr. Benjamin's reluctance to accommodate Mr. Heinze's request for a Google email address for communication while offering to call Mr. Heinze himself could be seen as unequal treatment. This discrepancy in communication methods might be interpreted as a sign of personal bias against the defendant. These instances taken together paint a picture of a prosecutor who may be allowing personal feelings to influence his professional conduct. Mr. Benjamin's actions and words appear to go beyond mere legal disagreement and venture into the realm of personal animosity and potential prejudice against the defendant. On hearing number 2, Mr. Benjamin's actions and words in the transcript, while not overtly biased or constituting misconduct, could be perceived as aggressive due to the following: forceful assertion of rights. Mr. Benjamin forcefully asserts the state's right to all of Mr. Heinze's recordings and videos, stating, "We have the right to everything." While legally accurate, the forceful language could be perceived as aggressive, especially considering Mr. Heinze's self-representation and potential unfamiliarity with legal procedures. Lack of explanation or guidance. Mr. Benjamin does not offer any explanation or guidance to Mr. Heinze regarding the discovery process or the reasons behind the state's entitlement to the evidence. This lack of communication could be perceived as unempathetic and potentially intimidating to someone unfamiliar with legal proceedings. Emphasis on states' rights. Throughout the exchange, Mr. Benjamin repeatedly emphasizes the state's rights and the court's authority. While this is his role as a prosecutor, the repeated emphasis, especially in contrast to Mr. Heinze's self-representation, could be perceived as an aggressive tactic to assert dominance in the legal process. Implication of guilt. Mr. Benjamin's statement, I know that there have been recordings, because we have seen portions of recordings on YouTube and such," could be interpreted as implying Mr. Heinze's guilt before the trial has even begun. This could be seen as prejudicial and potentially harmful to Mr. Heinze's defense. While these instances do not definitively indicate personal bias or misconduct, they highlight a communication style that could be perceived as aggressive and potentially harmful to a defendant who is not represented by an attorney. Hearing number 3. Mr. Benjamin's personal bias against Mr. Heinze is evidenced in several instances throughout the transcript. On page 2, he assumes Mr. Heinze will publish witness information online, stating, "We don't have to guess about it. We know for experience, because he's done that." He also insinuates that Mr. Heinze is getting others to do his dirty work, stating, "Maybe Travis Heinze operates under the assumption that he can procure others to do what he himself cannot or should not do." These statements show a clear bias against Mr. Heinze and a presumption of guilt before the trial has even begun. Mr. Benjamin's misconduct is further displayed in his disparaging remarks about Mr. Heinze. On page 13, he accuses Mr. Heinze of trying to outsmart everybody by putting information online and claiming ignorance when others use it to harass witnesses. He also implies that Mr. Heinze does not understand that he is responsible for the actions of those who comment on his channel, stating on page 15, "I really don't think he understands that just because someone else, piggybacks on what he's put out there on his channel, that he can say, well, I'm not responsible for it, so it just kind of goes away." Additionally, Mr. Benjamin makes sarcastic remarks about Mr. Heinze's concern about being recorded, stating, "I'm probably being recorded is why I'm saying all this." These comments are unprofessional and unbecoming of a prosecutor. Mr. Benjamin's bias against Mr. Heinze is further evident in his focus on the potential for witness intimidation charges. On page 8, he invokes LARS 14129.1, the witness intimidation statute, and suggests that Mr. Heinze is close to or has exceeded the scope of witness intimidation. He reiterates this concern on page 13, stating that if this were a felony case, there would be another case opened against Mr. Heinze for witness intimidation. While it is the prosecutor's duty to protect witnesses, Mr. Benjamin's repeated focus on this issue even though it is not the subject of the current hearing, suggests a personal vendetta against Mr. Heinze. Furthermore, Mr. Benjamin's conduct during the hearing can be seen as an attempt to undermine Mr. Heinze's defense. On page 17, Mr. Benjamin interrupts Mr. Heinze's argument and accuses him of planning to record the witness videos, despite the judge's order not to do so. This interruption could be interpreted as an attempt to discredit Mr. Heinze in front of the judge. Additionally, Mr. Benjamin repeatedly emphasizes that the information in the videos is not new and that Mr. Heinze already has it in written form. This could be seen as an attempt to downplay the importance of the videos and limit Mr. Heinze's ability to prepare for trial. Hearing number 4. Mr. Benjamin's conduct could be perceived as inappropriate or unprofessional in the following instances: dismissive and condescending language. Mr. Benjamin uses dismissive language when referring to the defendant, Travis Heinze, such as decry, and he's done as much as he needs to have done at this junction. This language suggests a lack of respect for the defendant's rights and prejudgment of his case. Additionally, he interrupts Mr. Heinze multiple times and talks down to him, saying things like, "So I expect that nothing will be presented by him other than what we present." This condescending tone can be interpreted as an attempt to undermine Heinze's credibility and confidence in representing himself. It could also be perceived as taking advantage of the fact that Heinze is not a lawyer. Inflammatory and prejudicial statements. Mr. Benjamin makes inflammatory statements about Heinze, such as suggesting that it's not safe for the library witnesses to be around him, and that Heinze has created a bad situation. These statements could potentially prejudice the judge against Heinze and are not based on any evidence presented in the hearing. He also makes a sarcastic remark, "You should go travel," which is unprofessional and inappropriate for a prosecutor. This kind of statement could be seen as mocking the defendant and making light of the seriousness of the situation. Mischaracterization of facts and exaggeration. Mr. Benjamin appears to mischaracterize Heinze's actions, such as claiming that Heinze is harassing the library witnesses, when there is no evidence of this in the transcript. This could mislead the judge and unfairly disadvantage Heinze. He also exaggerates the potential consequences of Heinze contacting witnesses, suggesting that there will be a problem, without providing any basis for this claim. This exaggeration could be seen as an attempt to manipulate the judge's decision. Objection to legitimate requests and due process. Mr. Benjamin objects to Heinze's request to depose witnesses, a standard legal procedure suggesting that Heinze is abusing the legal process. This could be seen as an attempt to limit Heinze's ability to defend himself. He also seems to disregard Heinze's right to confront witnesses, stating, in a criminal matter, there's a right of confrontation in the Fifth Amendment, so he cannot have a deposition of the witnesses. While the confrontation clause applies to trial, it does not necessarily preclude depositions, especially in a case where the defendant is representing himself and may need assistance in gathering evidence. This could be interpreted as an attempt to deny Heinze a fair defense. These instances suggest Mr. Benjamin may be allowing personal bias to influence his actions and engaging in conduct that could be considered prosecutorial misconduct. The prosecutor's bias is evidence, and that's Jason Methvin, is evidence in their dismissive attitudes towards the defendant's need for an attorney. For instance, the prosecutor suggests that the defendant does not need an attorney because there's not a lot of trial preparation that would be required. This statement implies that the prosecutor believes the case is straightforward and that the defendant does not require legal assistance to navigate the complexities of the legal system. Additionally, the prosecutor questions whether the public defender's office would even accept an appointment on a case like this, further undermining the defendant's right to counsel. The prosecutor's bias is also evident in their inaccurate portrayal of the defendant's actions. They state that the charge is resisting arrest by giving false information, but later acknowledges that the charge is actually not providing information. This misrepresentation could be an attempt to make the defendant's actions seem more deceptive and intentional than they actually were. The prosecutor's misconduct extends to their interaction with the judge. They interrupt the judge multiple times, attempting to steer the conversation and influence the judge's decision. For example, when the judge is discussing the defendant's right to an attorney, the prosecutor interjects with their own interpretation of the law, stating, "I don't think that this is the case." This interruption not only disrupts the proceedings, but also attempts to undermine the judge's authority and impartiality. Overall, the prosecutor's conduct in this hearing raises serious concerns about their professionalism, impartiality, and commitment to upholding the defendant's rights. Their personal bias, misrepresentation of facts, and attempts to influence the judge all contribute to an atmosphere of unfairness and prejudice against the defendant. On May 2nd, 2022 hearing transcript, Prosecutor Benjamin displays potential personal bias and misconduct in the following instances. Misrepresenting the defendant's financial status. Benjamin argues that the defendant, Heinze, is not indigent because he was able to hire an attorney. He disregards the fact that Heinze's attorney was funded through GoFundMe campaign, not by Heinze himself. Benjamin also incorrectly states that the public defender's office determined Heinze was not indigent, implying that this determination was final and binding. This misrepresentation could be seen as an attempt to deny Heinze his right to a fair hearing in the issue of indigency. Disparaging the defendant's character. Benjamin portrays Heinze as a transient and unreliable because he was literally living in a vehicle. This characterization is irrelevant to the issue of bail and could be seen as an attempt to prejudice the judge against Heinze. Impugning the defendant's attorney, Benjamin suggests that Heinze's attorney is not working pro bono, implying that the attorney is motivated by financial gain rather than genuine belief in Heinze's case. This could be seen as an attempt to undermine the credibility of Heinze's defense. Misrepresenting the purpose of GoFundMe. Benjamin argues that the GoFundMe campaign constitutes income for Heinze, which is a misrepresentation of the purpose and nature of crowdfunding platforms. This could be seen as an attempt to manipulate the facts to support his argument against Heinze's indigency claim. Overall, Prosecutor Benjamin's conduct in this hearing raises concerns about his commitment to fairness and impartiality. His misrepresentations, personal attacks, and attempts to manipulate the facts could be interpreted as a personal bias against Heinze and misconduct in his role as prosecutor.